Have you ever worked part-time and wondered, do I have the same rights as full-time employees? Maybe you're juggling school, childcare, or a second job, and your boss tells you part-timers don't get the same benefits. But is that actually true under the law? The reality is that federal labor laws in the United States often make no distinction between part-time and full-time when it comes to core protections like minimum wage and overtime. But when it comes to benefits, health insurance, retirement plans, and leave rights, the rules can get complicated, and they often depend on hours worked, employer size, or state law. In today's video, we're going to break down the 5 biggest areas where part-time and full-time workers may have different rights, so you'll know exactly what to expect and how to protect yourself. Let's dive in. Part 1. Wages and Overtime, FLSA. The good news is that when it comes to basic pay, part-time employees have the same rights as full-time workers under federal law. The Fair Labor Standards Act, FLSA, applies equally to both groups. That means you must be paid at least the federal minimum wage, $7.25 per hour as of now, though many states set higher minimums. If you're a non-exempt worker and you work more than 40 hours in a week, you're entitled to overtime pay at 1.5 times your regular rate. Let's clear up a common misconception. Part-time workers aren't exempt from overtime just because they're part-time. If you typically work 25 hours a week, but one week your boss schedules you for 45, those extra 5 hours must be paid at the overtime rate, unless you're exempt for other reasons, like being a salaried, executive, or professional. Another important point, federal law doesn't guarantee a set number of hours for either part-time or full-time workers. Your employer can schedule you for fewer or more hours each week as long as they pay you for the hours you work and follow overtime rules. Where differences can arise is in predictable scheduling laws at the STA, state, or city level. For example, Oregon, Seattle, and New York City have laws requiring certain employers to provide advance notice of schedules, often targeting industries that rely heavily on part-time labor like retail and fast food. These laws protect workers from last-minute changes that make it impossible to plan childcare or attend school. Here's a real example. A part-time retail worker in California is scheduled for a 4-hour shift, but is sent home after 1 hour because business is slow. Thanks to California's reporting time pay rules, the employer still has to pay at least 2 hours of wages, even if the shift was cut short. So, when it comes to pay and overtime, part-time workers are on equal footing with full-time employees. You can't legally be paid less per hour or denied overtime just because you're part-time. The main difference lies not in wages, but in the benefits and protections we'll cover next. Part 2. Health Insurance and Benefits, ACA and ADEA. When it comes to health insurance and benefits, the differences between part-time and full-time employment start to show. Federal law doesn't require every employer to offer health insurance, but the Affordable Care Act, ACA, sets specific standards for larger companies. Here's how it works. Under the ACA's employer mandate, any employer with 50 or more full-time equivalent employees must offer affordable health insurance to workers who average 30 or more hours per week. That means if you're a part-time employee working fewer than 30 hours a week, your employer is generally not required under federal law to provide you with health insurance. But there's a key detail. Full-time equivalent doesn't just count bodies, it counts hours. If a company has 100 part-timers averaging 20 hours each, that can equal 50 full-time equivalents, triggering the ACA rules for the business as a whole. However, the requirement to actually receive coverage applies only to those working 30-plus hours. What about retirement benefits like 401ks? That's where ERISA, the Employee Retirement Income Security Act, comes in. ERISA doesn't require employers to provide retirement plans, but if they do, the law sets rules for eligibility. In the past, employers could exclude part-time employees who worked under 1,000 hours per year, but beginning in 2024, changes under the Secure Act now allow part-time employees who work at least 500 hours per year for 3 consecutive years, or 2 years, starting in 2025, to be eligible to participate in their employer's 401k plan. That's a big step forward for part-time workers. Employers may also set thresholds for other benefits, like paid time off, vacation, or sick leave. These thresholds are often based on hours worked or employee classification. For example, a company might say that only employees who work 32 hours per week or more qualify for full health and retirement benefits. However, states and cities sometimes add their own protections. For example, under San Francisco's Healthcare Security Ordinance, employers with 20 or more employees must make healthcare expenditures for workers who work at least 8 hours per week in the city, regardless of whether they're full-time or part-time. So the key takeaway is this. Under federal law, employers aren't generally required to provide health insurance or retirement benefits to part-timers working under 30 hours per week. But new laws like the SCURE Act are expanding retirement eligibility, and state or local rules may go even further. Always check your state and city laws and review your company's benefits handbook closely. Part 3. Leave rights, FMLA, sick leave, and state laws. Another area where part-time and full-time employees often see differences is in leave rights. Things like medical leave, family leave, and paid sick days. Let's start with the Family and Medical Leave Act, FMLA. This federal law gives eligible employees up to 12 weeks of unpaid, job-protected leave each year for certain family or medical reasons, like the birth of a child, adoption, or a serious health condition. But eligibility isn't automatic. To qualify, you must 1. Work for an employer with 50 or more employees within a 75-mile radius, and 2. Have worked for that employer for at least 12 months, and 3. Have logged at least 1,250 hours in the past 12 months. That works out to roughly 24 hours per week on average. So, if you're a part-time worker putting in fewer than 24 hours a week, you may not meet the 1,250-hour threshold, and you won't qualify for FMLA leave. Full-time employees, by contrast, usually qualify more easily. What about paid sick leave? Here, state and local laws matter a lot. There's no federal law requiring paid sick days, but more than a dozen states, including California, New York, and Massachusetts, require employers to provide it. Importantly, in many of these states, both part-time and full-time employees accrue sick time at the same rate, typically based on hours worked. For example, in California, employees earn at least 1 hour of sick leave for every 30 hours worked, regardless of part-time or full-time status. Some cities, like New York City and Seattle, go even further, requiring paid sick leave for workers in small businesses. These local laws often cover part-timers explicitly because policymakers recognize that illness doesn't care how many hours you work. Another consideration is vacation time or paid time off, PTO. Here, the law generally doesn't require employers to offer PTO at all. It's considered a fringe benefit. But if a company does offer PTO, many states require it to accrue fairly. For example, in Illinois, accrued vacation is treated as earned wages. If your employer offers vacation, they cannot deny you accrual just because you are part-time, unless the policy clearly sets eligibility requirements. So here's the takeaway. When it comes to leave, full-time employees are more likely to qualify for job-protected federal leave, like FMLA. But for paid sick leave, part-timers often enjoy equal rights under state and local laws. Always check your hours worked, your company's policy, and your state rules to see what applies to you. Part 4. Equal job protections, discrimination, harassment, and workplace safety. While part-time workers may face limits on benefits or leave, there are some rights that apply equally to all employees regardless of hours worked. These include protections against discrimination and harassment, as well as the right to a safe workplace. Let's start with discrimination laws. Under Title VII of the Civil Rights Act of 1964, it is unlawful for an employer to discriminate against any employee, full-time or part-time, based on race, color, religion, sex, or national origin. This applies to hiring, firing, pay, promotions, and other terms of employment. Similarly, the Americans with Disabilities Act, ADEA, protects employees with disabilities, and the Age Discrimination in Employment Act, ADEA, protects workers over 40. These laws do not say only full-time employees are covered. They apply to all workers. For example, imagine a part-time cashier who is denied a promotion because of her pregnancy. That's still pregnancy discrimination under Title VII, even though she's not full-time. Or suppose a part-time janitor is harassed with racial slurs. He has the same right to file a complaint with the Equal Employment Opportunity Commission, EEOC, as a full-time employee. The same goes for retaliation. If you report discrimination or harassment and then lose your job, that's illegal, whether you were working 10 hours or 40 hours per week. The EEC enforces these rights for all employees. Now, let's look at workplace safety. The Occupational Safety and Health Act, OSHA, requires employers to provide a workplace free of recognized hazards. This duty applies to everyone on the payroll. Whether you're part-time or full-time, if you're exposed to unsafe machinery, toxic chemicals, or unsafe practices, your employer must fix the problem. And if you file a safety complaint, OSHA protects you from retaliation. Workers' compensation is another area where part-time and full-time are usually treated the same. If you're injured on the job, you may be entitled to medical care and partial wage replacement, no matter how many hours you normally work. The exact benefits depend on state law, but the right to coverage typically does not disappear just because you're part-time. So in these critical areas, anti-discrimination, harassment protections, workplace safety, retaliation laws, and workers' compensation, the law treats part-time and full-time workers as equals. Employers cannot use your part-time status as an excuse to deny you these rights. The takeaway, when it comes to basic fairness and safety, the law doesn't care how many hours you work. Every employee deserves dignity, protection, and a safe place to earn a living. Part 5. Job security, unemployment insurance, and practical tips for part-time workers. Now let's talk about job security and unemployment insurance, two areas where part-time workers often have questions. First, job security. In the U.S., most employment, whether part-time or full-time, is at will. That means your employer can generally terminate you at any time, for almost any reason, or no reason at all, as long as it's not discriminatory or retaliatory. Part-time workers are not less protected here. The same rules apply. If you're fired because of your race, religion, age, disability, or because you asserted a legal right, that's unlawful, no matter how many hours you worked. But outside of those exceptions, both part-timers and full-timers face the same at-will employment reality. Now, unemployment insurance. This is where hours can matter. Unemployment benefits are governed by state law, but generally, eligibility depends on your earnings and work history during what's called a base period. If you worked enough hours and earned enough wages, you may qualify for unemployment benefits, even as a part-timer. But if your hours were too low, you might not meet the threshold. For example, in some states, you must earn at least a few $1,000s during the base period to qualify. A part-time worker, averaging 10 hours per week at minimum wage, may fall short, while someone working 25 to 30 hours per week might qualify. It's also worth noting that unemployment benefits are usually based on your prior wages, so part-time employees who qualify may receive lower weekly benefit amounts than full-time workers, since the calculation is tied to earnings. Another key area is practical workplace tips. Part-time employees can protect themselves by keeping accurate records of hours worked and pay received to ensure overtime or minimum wage violations don't slip through. Asking HR about eligibility for benefits like health insurance, 401k participation, and paid sick leave. Sometimes benefits are available after a certain number of hours or months of service. Checking state and city laws because local ordinances often expand protections for part-timers, especially in retail and hospitality. Joining a union where possible. Many unions negotiate protections for part-time workers, including minimum guaranteed hours, advance notice of schedules, and access to benefits. Here's a real-world example. A group of part-time grocery store clerks in Chicago were regularly scheduled for on-call shifts. After Chicago passed its Fair Workweek ordinance, those workers gained the right to receive advance notice and predictability pay, giving them more stability. The bottom line, job security rules are the same for everyone. Unemployment benefits depend on your earnings, and part-timers need to be proactive in understanding both company policies and state laws to make the most of their rights. So, what rights do part-time employees have compared to full-time workers? When it comes to the basics, like minimum wage, overtime, workplace safety, and protection from discrimination, the law treats you the same. But when it comes to benefits, health insurance, retirement plans, and leave protections like FMLA, part-time workers may face limits, often tied to hours worked or employer size. Unemployment eligibility is also possible, but depends on your earnings history. The key takeaway is this: being part-time doesn't mean being unprotected. You still have important rights, and in some states and cities, you may even have stronger protections than you think. The challenge is knowing which rules apply to your situation. If this video helped you understand your workplace rights, hit like, share it with your coworkers, and subscribe for more plain English explanations of labor law. And drop a comment. Are you part-time and have you ever struggled with missing benefits?